Hi everyone, my name is Ricardo, and today we're going to talk about Marbury versus Madison and why it was and still is considered to be a pivotal case from the Supreme Court and what that means to us in today's modern world. So, first and foremost, it is important to understand that the Constitution was written in a way that separated powers between three different governing branches. You have the legislative branch, which makes laws, you have the executive branch, which carries out the laws, and lastly, you have the judicial branch, which interprets the laws. Now, why is this separation of powers important? Basically, it's to keep each other in check and balance each other out so that no one has more power than the other, which can then result in an act of tyranny from one branch to the others. We don't want a communist regime to overtake our democracy and govern the people with an iron fist and make people do things the way the government wants it to be done with no say from the people in the matter. So, to summarize Marbury versus Madison, William Marbury was one out of 42 individuals selected to be a justice of the peace. Secretary of State John Marshall at the time forgot to deliver Marbury's commission, and thus, when James Madison took over as the Secretary of State under Jefferson, he did not issue the commission by order of Jefferson. Naturally, he sued and asked the Supreme Court to issue what's called a writ of mandamus, ordering the commission to be issued. The Supreme Court ruled that while it was definitely illegal to withhold his commission, they could not issue said commission because the Judiciary Act of 1789 conflicted with the Constitution. Thus, with this ruling, the courts established what we now know as judicial review. In other words, the courts established that any federal law that conflicts with the Constitution was invalid and thus unconstitutional. They supported this ruling under the Supremacy Clause, which is found in the Constitution. And as the textbook states, this cause, or I should say this case, established the basic principle that the federal judiciary is supreme in the exposition of the law of the Constitution. Well, before this case, it was really unclear on which branch within the government could actually declare what is or what is not constitutional. Although the branches were established to bring checks and balances amongst themselves, this further brought balance because it further supported the prevention of an overreaching government from enacting laws that could cause them to overreach, or even, I dare say, overthrow another branch in an act of too much power being established. But in reality, what does the Constitution say about the judicial review? Well, it's pretty shocking. It says absolutely nothing about it. Zero, zilch, nada. As I mentioned earlier, the justices use the supremacy clause within the Constitution to uphold their rulings. The supremacy clause of the Constitution of the United States, which is Article 6, Clause 2, establishes that the Constitution, federal laws made pursuant to it, and treaties made under its authority constitute the supreme law of the land, and thus take priority over any conflicting state laws. Well, how does this affect us in today's world? Well, it has been established as a foundation for other rulings that came later for the Supreme Court to rule that something was either constitutional or unconstitutional. Some examples include Miranda versus Arizona, or Gideon versus Wainwright, or even Brown versus Board of Education. In other words, we still see the fruits of this ruling being used by the Supreme Court whenever it has been challenged on what may be considered unconstitutional. If there's anything that I feel should be changed for this ruling for the current times that we live in, I would say that I would want to see the Constitution to include the power of judicial review within it so that it is clearer for those that interpret the Constitution to have no doubts or challenges against it. I only say this because we have recently seen in the courts that they can indeed overrule previous rulings, much like they did for Roe versus Wade, and as such, it affects what the courts will then continue to do in the future for their rulings. Although the Supremacy Clause is not directly saying anything about judicial review, I believe that this practice is something that should be protected at all costs so that we can continue to benefit from it and not have the possibility of it being ever challenged or overruled in the future. So I leave you with this portion of the opinion that was delivered in Marbury versus Madison, which reads, it is empathetically the province and duty of the judicial department to say what the law is. I hope you enjoyed this presentation. God bless you all, and best of luck in what is left of this course.